The prosecutor provides evidence 4 days before trial. What will the court do? I'm Tulsa attorney James Wirth. That's the scenario that we're dealing with here. This is a real-world case, the state of Oklahoma. It is Renee Estrada versus the state of Oklahoma. It's with the Oklahoma Court of Criminal Appeals F 2021-1389. And in this case, the defendant is charged with aggravated trafficking. And there was a lab test result that apparently came back positive, that the material tested positive for methamphetamines. So they're set, they're going to trial, everything's been completed. And then 4 days before trial, the state provides a new lab report from a different OSBI representative that they intend to call at trial along with this new report that wasn't previously provided. It turns out that the previous person that did the OSBI lab report that showed positive for methamphetamine, that person was fired and therefore is potentially not going to be available to testify. So they got a new lab test done, tested positive again for methamphetamine. They have a new representative from OSBI that they want to call. 4 days before the trial, they make that change. So the Oklahoma Discovery Code is pretty clear. It says all issues related to discovery, except as otherwise provided, will be completed at least 10 days prior to trial. So the statute says all discovery issues must be completed at least 10 days prior to trial, absent some other authority that says otherwise. So what does the court do? Well, the trial court says, not a big difference here in the change in report, so we're going to go ahead and allow it. Ultimately, the person is convicted. He gets 15 years and a $50,000 fine, and he appeals it and said, look, the court violated statute. I was not given at least 10 days advance notice of this evidence. So what does the Oklahoma Court of Criminal Appeals do under these circumstances? So one, I'd say the statute is pretty clear. All discovery issues must be resolved at least 10 days prior to trial. That's to prevent any kind of gotcha type games, any kind of evidentiary harpoons, any unfair play, from the state. Gives everybody an ample opportunity to know what's going to occur at trial in order to prepare for that. Well, the court here went ahead and decided that contrary to what the statute says, and it phrases it this way, the Criminal Discovery Code generally requires that the state disclose summaries of all testimony at least 10 days before trial. However, they're saying that there was no unfair surprise here, no prejudice to the defendant, and therefore, let me read the exact words, and no prejudice to the defendant from this technically belated disclosure, and therefore the court did not abuse its discretion in allowing evidence of the test result. So that's from the Oklahoma Court of Criminal Appeals. They seem to come from the perspective of a prosecutor. In seeing it that way, they have a very difficult time, it seems like, seeing it from the perspective of a defense attorney, and that may be because many people on the Oklahoma Court of Criminal Appeals were prior prosecutors, less so prior defense counsel. But they're saying because there was a prior lab result that showed the same thing, that bringing one in 4 days prior to trial is not a big deal, just switch them out. However, that doesn't look at things from the perspective of the criminal defense attorney, who 4 days prior to trial is understanding that one, either the state is going forward without a lab test, or the state is going forward with a lab test from this fired person from OSBI. They could be basing their defense and their research and everything into attacking the credibility of the fired employee, and maybe have concerns of come up with some issues related to the methodology used by that person. Then 4 days before trial, they switch it out. All those potential avenues and defenses are gone, and we have a new report from a new person that they know nothing about and no opportunity to investigate maybe why the previous person was fired. Are those issues going to be relevant to this new person? What history does the new person have? Are there issues with the methodology that they use? Essentially, there's just no time to look into those issues. So the fact that we're going from one positive meth test to another positive meth test from the perspective of the prosecutor, and apparently also the Oklahoma Court of Criminal Appeals, it's apples for apples. From the defense attorney perspective, they could be completely different, and there's no opportunity to look into what potential defenses may be available with the new report and the testimony from the new representative from OSBI. Meanwhile, different things that were planned, 4 days plus prior to trial when they're making those plans is now completely out the door. So I would say, one, it doesn't comply with the Discovery Code. Two, it was prejudicial, presumably prejudicial to the defendant, but that is how the Oklahoma Court of Criminal Appeals is currently handling things. So this one goes down as a loss for Mr. Estrada, and that conviction remains. If you're dealing with a criminal defense matter in the state of Oklahoma, you've got questions about an appeal or about trial level stuff, you're going to want to talk to an attorney privately and confidentially about that. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.